Bonjour à toutes et à tous. La séance est maintenant ouverte. Séance numéro 26.
I call the meeting to order. This is the 26th meeting of the Standing Committee on Public Safety. You will no doubt have noticed that the meeting hours have been extended until 7:30 p.m. tonight, so that if necessary, we can sit beyond 5:30 and complete our clause-by-clause consideration of the bill we are looking at today, C8. Pursuant to the order of reference from the House on October 3rd, 2025, the committee is meeting to consider Bill C8, an act respecting cybersecurity, amending the Telecommunications Act and making consequential amendments to other acts. I would now like to welcome our witnesses who will answer questions as necessary, and they are from the Department of Public Safety and Emergency Preparedness, Mr. Colin McSween, Director General, and Kellyanne Gibson, Director. From the Department of Industry, Andre Arbour, Director General, and David Gibson, Director. From the Communication Security Establishment, Stephen Bolton, Director General, and Richard LaRose, Senior Advisor on Cybersecurity. And we will now move to clause-by-clause consideration of the bill. As you will remember from the last time we met, we were at clause 17 because we had stood clause 11, so we will begin with 17 today. Clause 17 had been amended with BQ 15, and Mr. Ramsey had moved a sub-amendment that was unfortunately not in order. That sub-amendment from Tuesday is not in order, so we are now back to BQ 15. And if I understand correctly, Mr. Ramsey, you are moving a sub-amendment to that. Thank you. We plan to vote for BQ 15 insofar as we can move the following amendment in 17.1, removing the reference to the Minister of Industry. Yes, that is quite a simple sub-amendment. Industry drops, and there will be no reference to the Minister of Industry.
To have greater clarity on what this sub-amendment would do to the amendment BQ 15. So would we want to discuss, before we debate, is there any need or value to specifying more clearly the nature of that sub-amendment, MP Lloyd?
I'm just wondering who is responsible if we don't state the minister responsible?
So let's check that with the experts. Anyone would like to speak to that? Monsieur McSween?
Thank you very much for the question, Mr. Chair. Should the bill receive royal assent, the Minister of Public Safety is responsible for the CCSPA, and the Minister of Industry is responsible for the Telecommunications Act. As you know, right now, currently the Minister of Public Safety is the sponsor for the bill in its whole, but should it receive royal assent, those will be the responsibilities. And it's part of the reason that amendment is suggested is because then that could be interpreted to mean that the responsible minister would be responsible for reviewing their specific piece of the legislation.
Any further input into this sub-amendment? Est-ce que le sous-amendement...
Does the sub-amendment carry? The sub-amendment carries, and that brings us to BQ 15 as amended. Mr. Lloyd.
I'd like to move forward with my sub-amendment. That being said, I hope the indulgence of the committee, because it has been amended to remove reference to the Minister of Industry. My amendment was using some of the old language. The spirit of my amendment is to change the language to say within, and this has been sent around so everyone has it. But too often I think we've seen in previous legislation where we put in review clauses. I think of the SECU Act, for example, where reviews don't take place at the statutory 5-year review period. And I think it's been, several years overdue. And so what I'm seeking to do with this amendment is to create a requirement, and I think it's a flexible requirement, that within 5 years of this bill coming into force, that the minister responsible must complete a review of the legislation. And then within 90 days of the completion of that review, so 90 days from the maximum of 5 years, that the minister must complete a report on that review. And then and then it goes on to what the regular amendment was, which is within 15 days of the completion of the report that it be tabled in the House. And I think this creates firm accountability because as worded, it's not clear to me that the minister would ever actually have to table any report. They would undertake to do a report and a review, but there would be no actual statutory requirement for that report ever to be tabled in the House. Thank you.
Okay, just for clarity, is that a sub-amendment to BQ 15 or a different amendment?
It's an amendment to BQ 15.
An amendment to, sub-amendment to BQ 15? Okay, so has this been communicated to the clerk, the legislative clerk? Yes?
Je demanderais juste de clarifier.
Okay. So one question, just as you pointed out first, and you were very good in doing so, since this comes after this some amendment which was voted positively on, then there's a question of whether we include industry or responsible. So would you?
I consent to removing that.
Okay, so I'll pause for 15 seconds just to make sure that so no one is moving anywhere, and we'll make sure everyone is on the same page. The amendment, the sub-amendment would be what MP Lloyd pointed to, except, clerk, can I look at the, except that it would read, the Act receives royal assent, the minister must complete a review, as opposed to the Minister of Industry must complete a review. So everyone is on the same page? Good. So that leads us to discussing possibly that sub-amendment to BQ 15. Is there a debate on that? No? Est-ce que l'amendement...
No. Does the sub-amendment that has just been moved carry? The sub-amendment that has just been moved and debated is carried. And that brings us to BQ 15, which has been amended twice. Is there anything to say on the on BQ 15 as amended? No. Does BQ 15 as amended carry? Yes. BQ 15 is carried. This now makes it possible to go back onto Clause 11, which had been stood last week. And that is what we will be dealing with now. If we remember, Clause 11 had there had been an amendment moved, BQ 9, and if BQ 9 were adopted, CPC 40, which comes after, cannot be moved because of a line conflict. And if BQ 9 or CPC 40 carry, there would be a modification of confidential information as set out in BQ 10 and BQ 13, which come after. And amendments BQ 10 and BQ 13 will then not be moved if BQ 9 or CPC 40 carry, because they have an influence on each other and create a conflict. So a vote on BQ 9 will affect CPC 40 because of a line conflict, and it will affect the possibility of debating BQ 10 and BQ 13. So that said,
Madame de Bellefeuille?
Je ne veux pas le présenter.
I am withdrawing BQ 9.
Forget, on l'avait proposé la semaine dernière. Hein?
It had been moved last week, hadn't it? Last Tuesday. There was unanimous consent. Is there unanimous consent to withdraw it? I presume yes. Unanimous consent to withdraw BQ 9. So BQ 9 is withdrawn. And that brings us to CPC 40.
Being moved.
Move CPC 40.
Thank you, MP Lloyd. Debate on CPC 40.
Officials, can you give a reflection on CPC 40?
Thank you, Mr. Chair, for the question. In Part 2 of the Act, one of the challenges that occurs with CPC 40 is it does create significant confusion as to the way personal information would be administered under the Act, and this arises from the commingling of the definition of personal information with confidential information, and I'm happy to give you an example here. Personal information under the Privacy Act is accessible by Canadians. There's a requirement to retain that personal information for 2 years. Canadians can request that information, can seek to correct that information, and can seek recourse based on that information. The confusion here arises because that information would now need to be treated as confidential. And so it creates an interpretive question as to whether or not, if somebody requested that information under the Privacy Act, what would happen in that case? Would we need to keep it confidential, or could it be disclosed? What exacerbates this challenge is that in Part 2 of the Act, we have several organizations administering this Act, so not just public safety, but the regulators as well, too. And so it certainly, at minimum, creates a risk that it creates a conflict with the Privacy Act. There's also a potential challenge just in the administration of the Act as well, too. If personal information has to remain confidential, there is a question as to how that could be interpreted when a regulator was trying to exercise their regulatory power.
Thank you. Vote.
Thank you, MP Lloyd. Thank you, Mr. McSween. Any further input? Monsieur le député Ramsey?
I'd just like to say that in view of what's been said, and that in order to avoid this confusion, we will submit later on another amendment. If this, of course, if this amendment doesn't go on, so we will vote against this amendment.
For that, any further input? No? Okay. Is CPC 40 adopted? Donc, c'est le CPC 40 est
CPC 40 is rejected, and that brings us to CPC 41.
moved.
Yes, I'll be moving this.
Thank you, Ms. MP Lloyd. Any debate on CPC 41? Monsieur le député Ramsey?
Indeed, écoutez, on pense que dans cet amendement,
We believe that this amendment will restrict some incidents that might be subject to declaration, so quasi-incidents may no longer be signaled, and the example given is that only catastrophic weather events would lead to an alert, but by ignoring the forecasts that might announce them, this would reduce the scope of alerts. So therefore, we will be voting against CPC 42. Thank you. Any other comments?
Conservatives have moved forward with this based on the concerns of government overreach. Oh, sorry. Désolé. Conservatives are moving forward with this motion, this amendment, because there's been concern raised by civil liberties groups about the scope and the reach, government overreach potentially, and by focusing and including the word material, we're seeking to provide some level of comfort to Canadians that the impacts of this legislation, which is serious legislation, is meant to deal with serious problems. Thank you.
Merci. L'amendement.
Thank you. Is the CPC 41 carry? CPC 41 is rejected. And that brings us to an amendment that was added a little later, CPC 42.1. The CPC 49.1 has it been moved? Will it be moved?
.1 is being moved. Okay, so that there's been no notice has been sent some time ago. It wasn't sent. The notice wasn't sent in the initial package, but was sent a bit later. So we'll pause for a few seconds. I'll suspend for a few seconds.
I could explain it.
And then maybe MP Loddy can explain it, and then if there is a need for suspension, we'll suspend.
Yeah, so this amendment, I think it's quite uncontroversial. It came out of a meeting with the an association of internal auditors who expressed concern that they desire that there be a clear definition of what an internal audit is. And that definition is actually a definition that is included in the Treasury Board Act. It's the definition that Treasury Board follows. And so this organization expressed concern that there was no firm definition of internal audit and sought to include that in the legislation to provide more clarity. And I'd like to ask the officials to perhaps weigh in and reflect on that. Thank you.
The question. The consideration I would raise just in respect of this amendment is, yes, it's quite accurate to say that this definition is found in the Treasury Board policy, all in internal audit. The one thing to bear in mind, those policies are just that. They're policies of the government. They do have broad effect. All deputy ministers must adhere to the policies and the policy requirements, and so must use that definition. So there is some repetition there. I guess the consideration I would point out is that you would now be legislating that definition. Because policies are updated regularly, it runs the risk that that definition in the policy could change. It's also possible that the institute that created this definition could also change or adapt that policy, in which case you would bump into a situation where a Treasury Board policy would now be different from what's legislated in this particular act. Now, of course, it would be possible to go and update the legislation, but policies usually go a bit faster.
So my question is, if this is the definition that has been adopted by the Treasury Board, presumably that definition is being updated. I've been told by this organization that the government is involved in decisions about updating this, and that so where would there be a conflict with this act in particular if we were to include that, if the Treasury Board is already updating its provisions based on its own internal definition?
Thank you, Mr. Chair, for the question, and apologies, I should clarify myself there. All I said, it just creates the situation whereby there could be a difference. if the Treasury policy, if this is legislated in the Act and the Treasury Board policy stays the same and doesn't change, then you have the same definition. If in a year, for whatever reason, the institute that created that definition or Treasury Board in its capacity as the Policy Center for Government decides to change it.
Doesn't the Treasury Board definition also change? Because
it could, but it wouldn't automatically change in the legislation, and that's the issue.
I see. Thank you.
Okay, thank you, MP Lloyd. Any further input? I will suspend for a minute because I think it's better for everyone to vote with sufficient clarity, but it won't be a long suspension, so please don't go anywhere. On va recommencer, retourner au débat sur CPC 40.1.
We're going back, resuming our debate, CPC 40.1, hoping 41.1 rather. And we hope that it is now sufficiently well understood. Any comments or debate on 41.1? Does CPC 41.1 carry? Carried. And that should take us to CPC 42. But I believe that there was notice of a further amendment. Mr. Ramsey? Do you want me to read it? If you would. That Bill C8 in Clause 11 be amended by replacing line 32 on page 22 by adding the following. For greater certainty, nothing in this Act affects the provisions of the privacy. We'll go back. Adding after line 11 on page 22 the following. Personal information has the same meaning as in Section 3 of the Privacy Act. And B, adding after line 13 on page 31. For greater certainty, nothing in this Act affects the provisions of the Privacy Act in relation to the protection of personal information. Thank you, Mr. Ramsey. Any debate? Does the amendment carry? The amendment carries. And CPC 42.
Yes, I'll be moving CPC 42, and basically we're seeking to harmonize the standards by which this legislation is governed by. I'd like to ask the officials about the International Organization for Standardization and how that relates to national security. Do you believe that this harmonization would reduce national security?
Thank you, Mr. Chair, for the question. While generally speaking, it's a good practice to harmonize this, there are some considerations when legislating that requirement. As it relates to cybersecurity, there are different international standards bodies, and thus different organizations can follow different standards. Legislating a certain type runs the risk of requiring a certain group to adhere to that or those particular standards. The other issue with it, standards change consistently. So embedding those in legislation does run the risk of that provision stale dating quickly should there be a significant enough change. I don't know if my colleagues from CSE wish to add anything.
Thank you, Mr. Chair, for the question. Yes, indeed. I mean, this type of reference to a standard will be better placed in regulations when it can be quickly adapted or changed versus in legislation where if there was something that we didn't want to adhere to in that standard, we would be left with it in legislation. The standards deviate over time.
Appreciate it.
Okay. Monsieur le député Ramsey?
Monsieur le Président,
Mr. Ramsey? Chair, we would be ready to support this amendment, provided that our sub-amendment, the sub-amendment I moved, would be passed. So my sub-amendment to motion CPC 42, that motion number CPC 42 proposing to amend Clause 11 Bill C8 be amended by A, deleting in accordance with any guidelines established under Section 15.1, and B, by replacing must with may in proposed Section 15.1.
So you see everyone seems to be on board and well aware of the sub-amendment. Is the sub-amendment adopted? Le sous-amendement est donc adopté, ce qui nous ramène.
The sub-amendment carries, and that brings us to CPC 42 as amended. Does CPC 42 as amended carry? Very good. CPC 42 as amended carries. And that brings us to BQ 10. Is anyone moving BQ 10? No. And that brings us to CPC 43.
And there was significant, I believe, with the Privacy Commissioner and others, there was concern that the Privacy Commissioner was not required to be informed when there were privacy breaches. And so what we're seeking to include is a provision that will allow the Privacy Commissioner to be informed when there is privacy rights impacted. Thank you.
Thank you. Mr. Ramsey?
Oui, merci, Monsieur le Président. Nous allons.
Thank you, Chair. We will be voting against this amendment because we believe that it compromises this neutrality of the communication security establishment in its role of providing advice and direction to the industry, since it would be obliged to determine whether an incident report would satisfy to the criteria provided for under the Personal Information and Electronic Documents Protection and Electronic Documents Act, which is not within its purview. Thank you, Mr. Ramsey. Other comments? Does CPC 43 carry? It is rejected. And we move to Amendment G4. Is anyone moving G4? Is there not another amendment before that? Perhaps, yes? Yes, there is. Yes, you had given notice that there might be another amendment before G4. Are you moving that amendment? Yes. This is 21B for the clerk. Do you have that? Chair, the amendment reads as follows, that C8 in Clause 11 be amended by adding after line 24 on page 27 the following. For greater certainty, 18.1. For greater certainty, nothing in Section 17 and 18 affects the provisions of the Personal Information Protection and Electronic Documents Act. Thank you, Mr. Ramsey. Any further comments? Does the amendment carry? Carried. Is anyone moving G4? Yes. This amendment guarantees that directives under the bill cannot be used to decrypt private communications. So we believe that this amendment does meet the views of all members. It shouldn't pose a problem. Any debate? Does G4 carry? Carried. CPC 44.
I so move the amendment. I'd like to ask the officials further reflection on the amendment in relation to privacy rights of Canadians.
Thank you, Mr. Chair, for the question. We have no additional considerations to offer with this amendment. It's clearly in line with the policy intent of the bill. I don't have much to say beyond that. Thank you.
Thank you. Is CPC 44 adopted? CPC 4 adopted. Moving to BQ 11. Est-ce que l'amendement BQ 11 est proposé?
Is BQ 11 moved? No, it is not moved. It has not been moved. Therefore, we will move to G5. Is G5 moved? Yes. Please go ahead, Mr. Ramsey. C5 is a proactive amendment designed to ensure that the Governor and Council take account of necessity and proportionality before issuing any cybersecurity directives. This makes it possible to establish a legal norm for standards and provides additional assurance that directives will be used solely to protect essential cyber systems, critical cyber systems. So this amendment provides greater assurance. Thank you. Any comments? Does G5 carry? G5 carries. NDP 12, which is deemed to have been moved. Any comments on NDP 12? Does NDP 12 carry?
Motion for me, and I'd like to ask the officials to provide some clarity on what the impact would be.
Thank you, Mr. Chair, for the question. Simply stated, the amendment would remove the prohibition against disclosing the fact that a cybersecurity direction was issued to a designated operator and make the associated change in the disclosure when allowed section. So in layman's terms, it would allow a designated operator to indicate that they were subject to a cybersecurity direction.
Thank you. So is NDP 12 adopted? Okay. So I see it being rejected. So we will move to BQ 12. Est-ce que l'amendement BQ...
Is BQ 12 moved? No. So on to CPC 45.
being moved?
This motion, we're seeking to create a standard for information disclosure or collection, and like to ask the officials to provide some feedback on that. Thank you.
Monsieur le Président, j'aimerais entendre l'opinion.
Chair, I'd like to hear our experts on this.
So I do think there may be some unintended consequences with this particular amendment. So if the purpose of the amendment is to ensure that there are protections in place for personal information, I just would highlight that there's already a reliance on the Privacy Act, which has a definition of personal information and rules around its use, which this Act relies on. And then I would also highlight that the CSE Act also has provisions for the protection of personal information. The concern with this, though, is that it could unintentionally restrict CSE's ability to use the way it's worded. It could inhibit the CSE from using the information for its lawful mandate. So, in practical terms, it could affect CSE's ability to provide support to through its voluntary program to Canadian operators. So I think that's something that you may wish to consider as part of this amendment.
Merci. D'autres?
Thank you. Are there any other comments? Does CPC 45 carry? I'm not certain. Does CPC 45 carry? Rejected. And that brings us to CPC 46.
CPC 46 being moved.
Yes, I'll be moving this motion or this amendment, and it's seeking to provide, similar to the last motion, to create protections on the use of private information that isn't related to provisions in this Act.
Thank you. Any need for clarification or debate? Is CPC 46 adopted? CPC 46 rejected. BQ 13 ne peut pas être...
BQ 13 cannot be moved because it was contingent on the passage or adoption of BQ 9 and CPC 40, which did not pass. So that brings us to CPC 47.
Being moved.
Move this motion. I think there's a lot of concern when we're giving government new powers to, collect information for its mandate that what happens to this data when the circumstances with which that data was collected for that purpose is no longer the case. So what are the data retention rules? And we're seeking to provide clarity for Canadians that this data is not going to be held somewhere. We know the government itself is subject to cyber attacks, and so we don't think it's necessary for the government necessarily to hold this information if it's not needed any longer than necessary. And I want to ask the officials maybe if they can provide their insight on that. Thank you.
Thank you. Officials?
To the question, Mr. Chair. A consideration we'd offer for the committee is that this may unintentionally, again, restrict some of the privacy rights of Canadians, specifically as it relates to the retention of information and their ability to access information. Under the Privacy Act, there's a requirement for the government to retain information for 2 years, as I mentioned. In this case, as worded, there would be an obligation potentially to dispose of that information prior to that 2-year period, meaning that Canadians would lose that 2-year window if they were looking to access their information collected under the Act.
Thank you, and I think that raises an interesting point. Obviously we can't create legislation that directly counteracts with another piece of legislation. So, but there is nothing requiring under this amendment for any government body to dispose of that information before the 2 years. So they could keep it for 2 years and follow the Privacy Act rules and then dispose of it after that point. Could they not? Like what,
Thank you, Mr. Chair, for the question.
What mechanism would force them to delete
I believe the issue comes in where in the wording where it says it must be disposed of if it is no longer necessary for the purpose for which it was collected or obtained. So if that period...
Pardon? Madame la Béveille.
Je sais qu'il y a monsieur.
I know that Mr. Maxwell hasn't testified a great deal so far, but he's speaking extremely fast. Could he please slow down? Mr. McSwain, I think you understood the interpretation of what's just been said. Please do slow down.
Absolutely. Apologies. So sorry, going back, the issue arises with the wording, specifically here it says, must be disposed of if it is no longer necessary for the purpose for which it was collected or obtained or for verifying compliance and preventing non-compliance with the Act. So the interpretive read of that is that if I no longer need that, regardless of what the Privacy Act says, I have to get rid of it.
I would just draw the committee's attention to the next sentence after he completed it, or it says, it also finalizes, says, or in accordance with any requirement under the Privacy Act, which was what you cited, the 2-year Privacy Act rules, that applies to it, whichever retention period is shorter.
Thank you, Mr. Chair, for the question. Agreed, but it's the problem is whichever retention period is shorter, because so if you divide this up, if you take the first part of that sentence for the purpose for which it was collected, for verifying compliance, if that's shorter, it needs to be disposed of.
I'm going to move a quick sub-amendment to this then and request that...
Sorry, for procedural correctness, you yourself cannot do that, but
Just
someone
remove
else
that
could.
last, remove the whichever retention period is shorter. Can you move over?
Et Madame de Bellefeuille, vous avez aussi levé la main parce que je...
Mr. Bellefeuille, you had raised your hand because you wanted to speak. Yes, perhaps this could be done while I put some questions on the amendment.
We'll allow MPR and you to work together while Madame de Bellefeuille is able to ask her questions.
Oui, en fait,
Yes. In BQ 13 and CP 47, I believe, what we're trying to make sure of is that information is deleted when it's no longer necessary. In the current legislation, what we're trying to define, and since BQ was not in order, and since CPC 47 is being debated, can C8 and will C8 be clear enough on the fact that confidential information needs to be deleted when they're no longer needed. I believe, yes, that's already there. What happens now is that there are rules on the use of confidential information, but there are also rules under the Privacy Act, which includes definitions and rules on how the information can be used. If you want to be explicit, we could change the wording somewhat to add and the result would be that rules relating to this amendment would exist alongside the Privacy Act.
Okay. Parfait, OK. Parce que là, je comprends que M. Lloyd est en train de travailler avec son collègue pour peut-être déposer possiblement un sous-amendement, mais juste pour être plus certaine, parce que ça, cette recommandation-là, nous vient du commissaire à la protection.
Pardon, Madame de Bellefeuille, il y a un problème d'interprétation apparemment.
The microphone was off. Apologies. The microphone was off. It is back on. Right. The idea was that the wording of this motion was suggested by the Privacy Commissioner. And when the Privacy Commissioner makes a recommendation on his area of expertise, and he suggested that all information be deleted once it was no longer needed. There was a little bit that you said in English, and the interpretation wasn't quite there. If the word "and" is added, I gather this would be acceptable, and we would reach the goal that BQ 13 and CPC 47 were designed to achieve. It's just the current wording that creates a conflict. That conflict can be removed, and they can exist alongside one another. So may I move a sub-amendment and add "and" where Ms. Gibson indicates, to make CPC 47 more acceptable so that we can achieve the goal of having personal information deleted when it is no longer needed. I believe the sub-amendment has been well understood by the legislative clerks, but since it's becoming a little bit complex, I will suspend for a few moments to make sure that everyone on both sides of the table understands exactly what we're talking about. Suspend.
redémarre.
We'll resume after, I think, having taken an important break to make sure that everything was clear to everyone. Before suspending, we were talking about CPC 47. Ms. de Bellefeuille. Order, please. Ms. de Bellefeuille had submitted a sub-amendment. Ms. de Bellefeuille, could you kindly come back to that? Yes, after discussing the issue, I think we found a solution better than my amendment, which actually gets to where we want to be, so I'm withdrawing.
Bellefeuille withdrawing her sub-amendment. Okay, so the sub-amendment is withdrawn, which brings us back to CPC 47. Monsieur le député Ramsey.
Alors, le sous-amendement proposé.
The proposed sub-amendment, I'll read it in English because it's my...
It's defined in Section 3 of the Privacy Act that is collected or obtained under this act must be disposed of if it is no longer necessary for the purposes for which it was collected or obtained, or for verifying compliance or preventing non-compliance with this act, and in accordance with any requirement under the Privacy Act that applies to it.
Merci, Monsieur le député Ramsey.
Thank you, Mr. Ramsey.
Adopted on division, ce qui nous ramène au AC.
And that brings us back to CPC 47 as amended. Does CPC 47 as amended carry? CPC 47 as amended carries. And we now move to CPC 48. And there is another amendment before that. One moment, please.
C'est la... Celui-ci, c'est Madame la greffière.
The clerk has all my sheets. Our amendment would read as follows: that Bill C8 in Clause 11 be amended by adding, after line 24 on page 32, the following: for greater certainty 29.1. Nothing in this Act affects the provisions of the Communication Security Establishment Act in relation to the protection of personal information.
Merci, Monsieur le député.
Thank you, Mr. Ramsey. Any debates on this amendment?
Debate? No. So is this amendment adopted? Amendment adopted. Moving therefore to CPC 48. Is CPC 48 moved?
Yes, I'd like to move that amendment, and I'd like to speak on it. Yeah, we're seeking to add a confidentiality requirement for anyone who's exercising powers under these acts, and I'd like to ask the officials to weigh in on this. Thank you.
Thank you, Mr. Chair, for the question. We did struggle with the intent behind this provision. Our plain language reading of this is essentially that an individual responsible for administering or enforcing this act would not be allowed to share the name of any person who provided information under this act unless the law specifically requires them to do so. This would apply in any situation that could compromise a service or system that is vital to national security or public safety. So that is our interpretation. There is some considerations for the committee. Most prevalent, it could prevent regulators from clearly showing what information they relied on, including from whom, when determining noncompliance with the Act. If determination were challenged, for example, and regulators were asked to demonstrate the source of the information used, this motion would limit their ability to do so. It could make it harder to identify sources of information, limiting decision makers' ability to assess credibility and make fully informed decisions. It would add administrative burdens requiring new procedures, training, and legal checks to avoid unintended violations given the uncertainty around the provision. And obviously, it does impose strict confidentiality limits, slowing information handling, delaying coordination, and reducing flexibility administering the CCSBA.
Merci.
Thank you. Any comments? Does CPC 48 carry? CPC 48 is rejected. G6, is it being moved? Mr. Ramsey, the purpose of this amendment is to deal with the industry's concerns regarding personal responsibility. It reduces financial exposure to a maximum level that is more manageable, I would say, for individuals, including senior officials of these organizations, while ensuring compliance. So I think this is an amendment that should have the support of all members. Thank you, Mr. Ramsey. Mr. Bellefeuille? I'm curious to know why, when you drafted the legislation, you set this figure at $1 million, and now you want to bring it down to 500,000. That's quite a margin, 50%. I'd like you to explain the rationale underpinning that, because it's quite a difference. Why have the penalties changed so radically? That's because we've had an opportunity after C20, after the bill was introduced at C26, to speak with stakeholders. Every time I spoke with stakeholders from the industry, they said that they were afraid that people will not want to accept positions in cybersecurity because of this. It was a genuine problem. So that is why we listened and decided to bring that figure down. The reason why we had put $1 million there to begin with is that we wanted to be certain that people would take cybersecurity seriously. So now we're really trying to find the middle ground. Thank you. Does G6 carry?
Moving to BQ 14, est-ce que l'amendement BQ 14 est...
Is BQ 14 being moved, Mr. Bellefeuille? Yes, I am moving it, and I'm glad to. This amendment basically flows from discussions with the group bringing together a number of hydroelectric partners in the electric power sector, which is well regulated by North American system. They have some well-grounded fears that they explain to us, and we would like the government, the federal government, to have an obligation to consult provinces that have a hydroelectric power system and that are accustomed to meeting extremely high safety standards. So in Quebec, we have Hydro-Quebec, for example, and I think it would be certainly in the interests of those organizations to have an assurance that they will be respected by the government. So BQ 14 is designed to meet the very pressing demand that was not maintained in C26, but has clearly been shown to be significant. So I hope to have my colleagues' support for BQ 14. Thank you, Mr. Bellefeuille. Any debate? Mr. Ramsey? Out of principle, we can't support an amendment of this kind, because basically it says that the governor and council cannot ensure consistency with regulatory and standards regimes. It's as if outside organizations were being given the responsibility of deciding what's best for Canada, whereas it should be up to us to make sure the regulations do that. Of course, by seeing what others do and taking into account the requirements of organizations, we have a commitment to do this. But to say that the government of Canada can no longer determine the kinds of regulations it needs, regardless of where they come from, this would be reducing our own responsibility and basically not assuming our responsibilities as a government. In other words, we're going to vote against it. Thank you, Mr. Ramsey. Other views? Other comments? Does BQ 14 carry? BQ 14 is carried on division. CPC 14.
CBC 49.
We won't be moving it.
No, it cannot be moved because it is a line conflict. So thank you for removing it, not moving it, and I couldn't be moved anyway. Thank you. G7, is G7 being moved?
Oui, Monsieur le Président.
Yes, Chair. This amendment provides greater certainty to industry stakeholders because the government commits to consulting them when establishing and formulating regulations. And that makes it clear why we voted against BQ 14. I believe G7 does what the intent of BQ 14 was. Thank you. Mr. Bellefeuille? Just trying to understand, Chair, perhaps with the help of officials. If we vote for this amendment, what impact will it have on BQ 14? Does it work with BQ 14, or does it just add a duty to consult? I'm trying to understand how they work together. I think they mean more or less the same thing. Well, in essence, the same thing. There was already an obligation to consult in the legislation even before BQ 14, and now there's a further one with BQ 14, and now there's yet another with G7. So this does not eliminate or reduce the scope of BQ 14? No, it does not. It simply expresses a requirement to consult. Yes, exactly. I think BQ 14 is perhaps a little stronger, but they're saying, in essence, the same thing. So I don't think G7 reduces the scope of BQ 14 in any way. You said that BQ 14 was stronger, so it would prevail. Could the government use G7 to say, well, I'm not actually under an obligation to take account of the criteria set out in BQ 14? I don't think so. There could be some confusion, but there is already an intention and obligation to consult stakeholders under the regulation process. Well, we're used to a federal government that states it will consult, but then makes decisions and consults after the fact. This is a practice that we can observe, both now and in the past, in fact. What I want to ensure is that the confusion that you referred to would not lead to opening the door for the federal government to say, well, in view of the fact we have G7, we are not, in fact, obliged to take account of North American standards, which are extremely stringent. Do you understand what I'm trying to say? I'm very cooperative on the committee. I'm not against my colleague, Mr. Ramsey's amendment, but I also don't want to reduce the force of BQ14 because BQ14 really expresses the will of the industry, with which I strongly agree. So I could decide to not vote for G7 because it takes away nothing, really. I think BQ14 is more prescriptive. It obliges the government to consult. G7 is less prescriptive. They may consult. So there could be some confusion. Thank you.
Merci, Madame de Bellefeuille.
Thank you, Mr. Bellefeuille.
My question then, my clear question then is, does G7 add anything? It sounds like it's redundant then.
I think it could be, yeah.
Okay.
D'autres interventions? Other input? So is G7 adopted? So G7 rejected, defeated, which is then moving us to G8. Is G8 being moved?
Oui, absolument. Monsieur le Président,
Yes. Chair, we understand that there is no legislative or other obstacle preventing the exchange of information between entities in C8. Nonetheless, for greater certainty, we want through G8 to guarantee that solicitor-client privilege will continue to apply with the government communications. Say this is called a safe harbor communications. It was a concern of the industry, and it will facilitate the transmission of information without people feeling threatened. Thank you, Mr. Ramsey.
Is G8 adopted? G8 adopted. Ce qui nous amène à l'article 11.
And that takes us to the question, shall Clause 11 with multiple amendments carry? Clause 11 carries. Appendix 1 of the bill. Shall the schedule carry? Carried. Shall the title carry? Carried. Mr. Bellefeuille? Okay. Shall the bill as amended carry? The bill as amended is carried. Shall the committee order, shall the chair report the bill as amended to the House? Great. The committee so orders. Shall the committee order a reprint of the bill as amended for the use of the House at report stage? Very well. The committee so orders. And that now brings me to where I can congratulate you all. But what's even more important than congratulating you
J'aimerais, évidemment, dans le contexte
is that, given the very difficult circumstances, we would, on your behalf, like to offer thanks and congratulations to the team beside me.
I've been very pleased and very fortunate to have the company of Michel Legault. Today, of course, Andrew was there too, whom we know really, really well. But before Andrew came, there was also Nelly Winters, the legislative clerks. We have had the bureau du légiste qui est derrière beaucoup du travail qu'on a dû faire au cours des dernières semaines. Il y a aussi
We've had legal experts, we've had analysts taking part. The clerk, Paul, whom we getting to know better and better the technical staff who ensures that we can do our work, including our extraordinary interpreters who enable us to work together, and of course the witnesses who spent not only many hours with us, but also many hours preparing to be with us. So I think they deserve a hand to show our recognition.
Alors, écoutez, on a
Well, we've beaten our own record. I hope that no one is too disappointed. But before we leave you,
I would like to point out that next week is a writing week. The week after, we were supposed to host the Minister of Public Safety on March the 10th, but as many of you will have known, the Minister cannot come on March the 10th, which means that we are trying to have him come with his team on March the 12th, which is in 2 weeks from now on Thursday. We will be discussing together what we would do on March the 10th instead. So I just wanted to flag that to all members of this committee. And now turning to you, MP Gill.
Thank you very much, Chair. Chair, I would like to move a motion that has been tabled by my colleague, Frank Caputo, as of November 20th, 2025. And the motion reads as that the committee report to the House its grave concern about the rise of extortion, which is up 330% across Canada since 2015, including a 400% spike in British Columbia and a 500% increase in the Lower Mainland. And the committee further report its recommendations that the federal government use every tool at their disposal, including tougher sentences, more restrictive bail provisions, and other measures to crack down on organized crime to protect Canadians, their property, and their business. And this should be brought forward to everybody in both languages. Just want to confirm if that. And I would also like to continue to say a couple words.
Well, we'll pause for a second to make sure that everyone suspend for a moment so that everyone has access to that motion, which is, as you notice, MP Gill was circulated a little while ago. Alors, merci de votre patience.
Thank you for your patience.
The motion has been shared. MP Gill, normally I would turn back to you.
Well, thank you, Chair. Yes, I really do have been waiting patiently to discuss this very important motion that's been impacting the residents of my community from the Lower Mainland. As stated in the motion itself, we see numbers that have spiked like no other, like we've never seen before. We've seen these numbers jump to 400%, impacting our Lower Mainland communities. We see it as high as 500% in BC as well. So, this is extraordinary that what we're seeing, and that's why it's so important for myself, because I'm a BC resident. These are members of my community that have been asking me, hey, what do? We feel like our public safety is vulnerable currently. That's what my residents have been saying to me. We hear stories from families, because when you live on the ground, I had a member from the block the other day, he said, there's no way that there's people that are afraid of their lives living in Canada every single day. One of our block colleagues has said this. I encourage them to come to my riding, come to Surrey, where they say it's ground zero. Just recently, we had the mayor of Surrey come down to Ottawa. She has called for a national state of emergency. That's how bad it's gotten in Canada. That's how bad it's gotten in our community. For my residents of Abbotsford South Langley, for Surrey, for Lower Mainland residents, they are calling on the government to bring precaution, to bring justice to the ones that have been repeat offenders on our streets, and to tighten up security. They're asking for the Castle Law to be passed. Members in my community are so terrified. They're sleeping and they don't know if a bullet is going to come flying into their bedroom window. So they're choosing to sleep in their basements nowadays with their kids. Kids are saying, and the wives are saying to these men that I'm talking to in my community, they're saying, our wives and children are saying, don't go to work. Because they're scared if Papa goes to work, they don't know if he's going to return back home that night. Businesses are being shot at. Family members are feeling this pressure now more than ever. And it's due to just these extortion cases are ramping up. And the thing is, we've identified this problem. We went way back from over a year ago, where our Deputy Leader, Tim Opal, had brought forth a bill. It was called Protection Against Extortion Act. The bill had extortion in the writing of it. See, this is stuff that we tabled for tougher sentencing, for real consequences. Just this last year, in the fall season, we had the jail not bail bill being brought forward, which we encouraged our colleagues to adopt in the House as well. Sadly, that was voted down. Just this past week, around 7-10 days ago, we had a motion, again, on extortion that was brought forward to the House. It was to close the loophole of these fake asylum cases that are being brought up after these criminals are causing chaos and terrorizing our streets. They're using and abusing the loophole in the justice system to seek asylum, to stay in Canada. We encourage that, but we don't want them to be on our streets. We want them to be sentenced. We want them not to have the bail that they are currently receiving. They should feel the full thrash of justice in Canada, but they should not be out on our streets. We want to make sure that we bring this motion forward because our citizens, members of our nation, are terrified. They're looking for answers, and I encourage all members, I hope to seek unanimous consent throughout our committee here, and to engage with the members in their opinion, and my colleagues as well that I know that are very concerned on my side that are from BC as well. So thank you very much, Mr. Speaker. I'm looking forward to having unanimous consent on this motion.
Thank you, MP Gill. MP Ramsey?
I just want to say on the matter of extortion that our government has been very active on this matter. We have more boots on the ground. We have more tools, more means. But we all know that the problem of extortion won't be solved before we get lawful access. So I would expect then the other side of the committee to agree to expedite Bill C2, whatever it's going to be named, when it's going to be reintroduced. I think this is the solution for extortion as Mrs. Kirkland was there this morning, she heard the expert on the panel. She will concur that they were adamant that lawful access was the way to go to fight extortion. Madam Akan was there as well, and actually was the one who organized that panel. So we know what to do. We will do it, and it's just a matter of expediting lawful access when it's being introduced in the coming week. At this point, Mr. President, I would like to move for adjournment for today.
Okay. So that's a motion on which we need to move immediately, and it's move to decide immediately.
Point of order.
Yeah, there's a motion.
So you want to adjourn the meeting? Okay.
Point of order. Mr. Chair, Mr. Au clearly indicated to the clerk that he would like to speak before Mr. Ramsey took the floor and before you gave it to him. And I would like to ask unanimous consent of this committee to give Mr. Au a few moments to say the words that he wished to speak to for his residents in British Columbia.
I hear you. This is a motion on which we need to move right now. I saw Mr. Ramsey first, and then I did note that Mr. Au, MP Au, wanted to speak, and I also added your name, MP Kirkland. This being said, we have a motion to adjourn the meeting, and we need to vote immediately to see whether that is the will of the committee. So is the committee wanting to adjourn the meeting? So we'll have a recorded division, just to make sure that we all understand. So please proceed to a roll call vote.
Thank you, Mr. Chair. The vote is on the motion that the meeting be now adjourned. Mr. Ramsey?
Yes.
Mr. Assassi?
Yes.
Mr. Hanley?
Yes.
Madame Akan?
Can I make a comment before I vote for it? Just a good.
No.
Yes. Thank you.
Mr. Lloyd? Mr. Gill?
Nay.
Ms. Kirkland?
No.
Mr. Au?
No.
Madame de Bellefeuille?
Oui.
So the meeting is adjourned.